What's up, everyone, and welcome back to King's Advisors. So today, we're doing something a little different. It's been a while since I've done one of these, but there's some relatively big legal news going on, and I want to talk about it. About a year ago, Gina Carano filed her lawsuit against Disney, and it's been kind of a crazy battle since then. We went over the pleadings in both her complaint and then Disney's answer, and then her attorney's answer to their answer. And it's been very interesting. I really enjoyed that what her attorneys are doing. I think they're doing a really smart thing, coming at it from the California law. Filing in federal court is a great thing because, as I've said a couple times, by filing in federal court, what they have to use California's law, but you get federal judges. And shockingly, I know we all know what's going on in the country so far, but due to Trump's first term, there are a lot of conservative federal judges. It just so happens that one or two of them are kind of being an asshole. But I digress. So I want to talk about what happened today. So today, Gina Carano won a motion to compel. Well, what does this mean? There are a lot of people on the internet today talking about how this is a huge win. Fact of the matter is, it isn't. It is a good win. It is a win that should happen. And if you believe in the system like I do, of course it was going to happen. So let me kind of go from a 10,000-foot view here. The first thing I want to talk about is discovery in general. So there are basically three parts of discovery: interrogatories, request for production, and depositions. There's also kind of a fourth one, which is request to admit, which are basically you admit that X. So in Gina Carano's case, you might put in there, you admit that Gina Carano was unfairly fired. Obviously, they're going to say no. Requests to admit are usually just so you can go ahead and get simple stuff on the record. Interrogatories are quite literally just questions. Requests for production are where you kind of get the body of everything. You get large files. You might ask for every contract that Disney entered into or that Lucasfilm entered into with actors and actresses from July of 2017 through July of 2020, something like that. That's just an example. And then, of course, depositions are where you sit down and basically interview people involved in the case. So in this case, one of the people I expect they'll try to depose is Pedro Pascal. I think that would be a fly on the wall for that. I think that'd be pretty cool. So let me kind of stay in that 10,000-foot view and look at this. Okay, so Gina Carano files her lawsuit. They go through everything, and then finally they issue discovery. And when discovery is issued, you have a certain time before you have to hand it over. Unfortunately, I can't really remember what the time is. There are differing rules for differing things. Some cases it can be 21 days, it could be 6 months. It really kind of depends on what's agreed upon by the parties. But let's say you hit that deadline, which we know that Disney hit that deadline because a motion to compel was filed. So let's say you hit that deadline. Then there's a couple things you can do. You can say, the attorneys can kind of work it out and say, you know what, John, if you get it to me by the end of the week, we're good. Let's say let's say that deadline is Monday. So let's say today's the deadline. I might call up the other attorney and say, hey, if you can have it to me by Friday, we're good. I won't, no motions, no sanctions, anything like that. But if they continue to not give it to you, well, then you can do what Gina's attorneys did and file a motion to compel. And all a motion to compel is a motion filed by the moving party. So in this case, it's the plaintiff, to requests that the court order the defendant, Disney, to supply the discovery that's being requested. In this case, from what I read, the discovery that they were refusing to give out was the contracts and money that people like Pedro Pascal earned from season 3 of The Mandalorian. Now, why is this important? Well, in order to prove damages, because you have to prove damages in order to get them, because she's asking for damages. She wants the money that she would have earned during season 3. So in order to prove that, she's got to prove liability, harm, and the amount. These documents are crucial to proving the amount. If Pedro Pascal, who was the star of the show, so she, if he got $1 million an episode, she's not going to be able to say he got $1 million, I want $1 million. But it shows a consistency. It shows a pattern. So if, let's say, I'm trying to think of someone who was kind of in there a couple of times. The Asian lady from Ahsoka. Okay, I forget what her name is, but she's in a couple episodes. Maybe they request her contract so that they can prove that, well, she got $100,000 an episode. So Gina would have gotten a little bit more than that because she was in more episodes, or she would have been in more episodes had she not been erroneously fired. So that's kind of where that's the purpose for what's being requested, to prove that there is damage or the amount of damages. Any other stuff is kind of, in my opinion, sort of obvious. Like, obviously there's harm, you're fired, that's harm. And liability, that's easy to prove. They're the ones that fired you. So we've gone over discovery. We've kind of looked at it from a 10,000 foot view. Disney has, or had, obviously they weren't successful, but there are defenses that Disney could have had. One of them is irrelevance. Well, irrelevance is kind of out the window because what other people on the show was making are clearly relevant to what she might have made as a recurring star. There's privilege. Other people's contracts are not privileged. And then one of them is undue burden. Undue burden is going to be something that I expect Disney to plead a lot of in this case regarding discovery. And what undue burden means is that it would be ridiculously expensive for them to get the documents. This is something that you see a lot of in large civil litigation, in class action. It's also something you see in older cases. So probably about 20 years ago, you might see this for anything that required, let's say 5 weeks of combing through boxes and stuff to find these documents. Well, it's unduly burdensome to corporations and companies, depending on the size of those corporations, to pay someone to just go through these boxes and look for these documents. Now, today, you have less of an argument for that, in my opinion, at least, because the most of these documents would be online. You could just search, Pedro Pascal contract, 2020 through 2025, whatever, something like that. So that's kind of what I would have gone if I was Disney's attorney, I should say. I would have argued that's unduly burdensome. It's probably the best one there. You can argue timing, which is that it would cause too much of a delay to get it. I don't think that's going to work. But I wanted to make this video because I wanted to help explain discovery. A lot of what you're going to hear me say is on these sort of videos, and any live stream that I do about legal stuff is based on my experience. It's based on how I understand things work and how things have worked for me here in South Carolina. Things are going to work differently in federal court. They're going to work differently in other states. Understand that this is not legal advice. This is just my opinion, basically, on how and what these things mean. Again, I don't think this is nearly as big a victory as some people on the internet have said it is. it's definitely a victory. Anytime the judge sides with you, you get this sort of feeling that, okay, that's one checkbox for me. Score one for Gina Carano. But in my opinion, this is something that Disney was really dumb and basically forcing the judge to side with Gina on. I think their attorneys did a bad job here. They should have made sure that this information was out there sooner. This is sad because Disney's probably paying these guys, millions of dollars a year. They're probably already up to $500,000 on this litigation, would be my guess. And they've just done a really bad job. I don't think they've done a very good job. Their defense actually does sound better now. I'll talk about that later. Something big happened last week. But yeah, I mean, this is definitely shaping up to be more interesting, and I am glad that Discovery is at least coming up in the vernacular of the conversation. But until next time, guys, hope you have fun enjoying this. I hope you learned something. If you have any questions, let me know. Don't forget to like, subscribe, and follow me on Twitter at KingSadvisors_.